Okay, guys, so we have a ton that we're going to go through. This might be a long stream, and not just because we go off and get long-winded. We are going to be looking at Jonathan Majors' appeal, what happened at trial, why I'm going to argue we shouldn't even have gone to trial in the first place, and with the recent Harvey Weinstein appeal, appeals court, High Court of New York says we're going to overturn that because of what? Something that's very relevant to evidence used in the Jonathan Majors trial. We're going to do a deep dive on all of that. To start off, we need to understand that New York doesn't have a clearly delineated statutory code that says these are the rules of evidence. What they have instead is a pile of case laws that it's been put together in a guide and kind of got to go through it and interpret it. And the flip side of that is when there's a new decision from an appeals court, new case law, especially when it's from a high court, it's very influential because that's what their entire, rules of evidence is derived from, because there's no statutory code. It comes from the case law. So Harvey Weinstein's case gave us a ton of new case law on Molineux evidence regarding prior bad acts and their admissibility in a criminal defense case. There's a lot, guys. Before we jump in, there's a few things, and some of them might seem out of place for me to blather on about right now, but I want to pin the idea. I want them to be in your head while we're going through everything we're gonna go through. In the Majors case, because we're going to be talking a lot about this appeal decision and what happened in the Harvey Weinstein case. For Majors, the complainant, Grace Jabari, was the only Molineux evidence witness. We may have heard about, the two other people that spoke to the New York Times, but that wasn't actually something that came in during trial. However, we did have Molineux evidence, and the witness was the complainant herself. So that's interesting, and that's not something that we have in the Harvey Weinstein case. In the Majors case, defense was not asserted, and that's not really a difference from the Weinstein trial, but really what I'm getting at is with Molineux evidence, we're not going to dive too deep into this, but there is when you assert a defense and the defense is presenting their case in chief, you have the opportunity as the prosecution to, more than usual, to ask for some Molineux evidence to be admitted to counter the defense being made. So, we've talked about why Jonathan Majors didn't assert an affirmative defense, a self-defense justification. We've also talked about why he didn't take the stand, but a lot of the stuff we're going to see here could shine some light on that. Third thing that's really important and a huge distinction from the Harvey Weinstein case is that the fact finder, the jury, did not find intent in the Jonathan Majors case. This is going to be huge for a lot of reasons while we're going through the admissibility of Molineux evidence. It's also really important to remember that what he was convicted of, it was reckless, no intent. So if his appeal were to go through and the court says, all right, we're overturning this, we're reversing it back down to the trial court, the prosecution can decide if they want to retry this or not. We already know that at sentencing, the district attorney did not ask for jail time for Jonathan Majors. So I'd be really shocked if they wanted to retry this case for a lot of reasons, right? But if you wanted to retry this case, even if the appeal issue isn't the Molineux issue, it's reversed for some other issue, there's a problem, because now you're only retrying for things that don't involve intent. And if you're not going after something that involves intent, there's no reason for Molineux evidence. So that would reduce, if we redid the whole trial over, that would reduce the remaining testimony to just what happened on March 25th. That would shrink hours out of the testimony evidence that was presented at the trial. So that's a huge difference, something to keep in mind. The other thing, in this case, and it's something that we do not have in the Harvey Weinstein case, evidence of the complainant possibly being the aggressor. Now, a lot of that evidence was withheld from the jury in the Jonathan Majors trial, but some of it still got in, including Grace Jabari's own testimony of, yes, I started the physical fight, I was trying to get the phone from him, or yes, I was chasing him because I just wanted to know who the woman was. I wanted to see the phone. I wanted to ask him about his infidelity. Yes, I struck him again. I was trying to grab him because I didn't want him to leave the car the second time they got in the car. All of that, right? We don't have that in the Harvey Weinstein case. And as we go through, you're going to see why that's relevant in a new way that we haven't talked about before as we go through this new appeal decision from the Weinstein case. Another difference. Prosecution argued pattern of abuse in the Jonathan Majors trial. A pattern of abuse. The charges only relate to March 25th. So again, as we go through some of the what's now going to be case law because of this high court appeal, keep that in mind. And then Sandoval, we're not going to get too deep into that, but Sandoval involves the idea of, hey, if I take the stand, I'm the defendant in a criminal case. And if I take the stand, are you allowed, as the prosecutor, are you going to be allowed to ask me about things that fall outside the scope of what I'm being charged with? Now, these are usually things that are determined before trial starts with a motion in limine. So with a motion in limine, the judge would say, hey, that's not going to be okay, or yeah, we'll allow it, whatever the case may be. In the Weinstein case, it's known that the prosecution asks for and was given permission to ask him about prior unrelated things. Like, did you ask somebody to lie before? We'll see some of it, but did you do this other thing that would look bad on your character? And we don't actually know, I have no idea, if this was something that was, pre-trial motions, anything like that. I'm not aware of any Sandoval debates happening in the Jonathan Majors trial, but it is something that could go to him choosing not to take the stand. Because once you get up there, it could have opened a can of worms. But I don't know that. Just throwing it out there so we're covering, all the possible overlaps we might talk about today. And with that, if you're joining late, we did already mention that New York is really great because they don't have rules of evidence codified. There's no statutory code that says these are the rules of evidence and the procedure for deciding if something's admissible or not. It's all derived from a bunch of scattered judicial decisions and case law. And what we get, we have a little bit of something here. This is the current guide to New York evidence. And I want to show you what it says at the bottom here. It's great. Or maybe I don't know exactly where it is, but somewhere in here it says, hey, this stuff is drawn from various decisional law rulings. And they sprinkle this throughout. Hey, what we just went over, it's derived from a bunch of decisions. It's not codified into law by statute. So, if you've been questioning Judge Gaffey, maybe there is a vagueness here, but what just happened with the Weinstein appeal? That was a high court decision. It's pretty damn binding. And I'm not going to go through this, but if you do want to look at this, New York does have a general guide to evidence, even though they don't have a delineated code. What I do want to cover is a short version of what actually, and I'm going to make myself tinier, make this a little bigger. It's still going to suck to read because the margins don't collapse if I grow it any bigger. But these are what we have extracted when it comes to determining the admissibility of Molineux evidence. So there's 4 elements, really, 4 key parts that a judge should go through in his determination, his or her determination, and this is what they are. The proponent of such evidence, the people, so that's the prosecution, must identify the non-propensity purpose for which the evidence is offered. In other words, you can't just bring in a bunch of evidence of potential prior bad acts, uncharged, untested, or even if they've been charged and someone's been convicted on them. You can't just bring those in just to say, hey, the defendant has a propensity for this. So they have to identify a non-propensity purpose and demonstrate its probative value on a relevant issue in the case, such as motive, intent, or identity. This is exactly why I highlighted that the fact finder in the Jonathan Majors case found no intent. So even if something's reversed back to trial, they're going to be looking at those 2 charges that stuck, and they'd be retrying on that. And intent couldn't be one of these issues that the prosecution could say, well, we want to introduce all this prior Molineux evidence that Grace Jabari wants to testify to. because it can help us establish this relevant issue in the case, intent. And we don't need to establish his identity. So what would they argue if they had to retry this? What would they argue to get that Molineux evidence in this time? The next thing for admissibility that the judge needs to consider, defense counsel may then argue that the issue or a fact upon which the evidence is offered is not relevant, or that such evidence is not necessary. So, where intent is readily inferable from the act alleged. Now, this is actually really relevant in the Weinstein case because that's talking about graping, right? And the idea there is, the charge itself is, there's no intent. So, or its admission would unduly prejudice the defendant by tending more to show criminal propensity than provide proof on some other relevant issue in the case. It's important to keep in mind that the people bear the burden of establishing the probative value of such evidence, and that the defendant committed such prior bad acts by clear and convincing evidence. Now, when we look at this in the Jonathan Majors case, the only person we had prior bad act evidence from was the complainant, which is a credibility issue in and of itself. So the prosecution's supposed to bear the burden, not just establishing how it's more probative than prejudicial to introduce in their case against Jonathan Majors, and that it was actually committed, that those things actually happened, right? So there's three things here, really. It's got to be probative, they bear the burden of proving it actually happened, and it's got to be clear and convincing. But the only evidence we had was the testimony of Grace Jabari herself and a photo or two that she characterized. So I think there's an argument about all three of these. Gaffey should have said no. But at the same time, you don't really know this until after it's introduced. You can't know all the testimony until there's testimony. But such evidence, if allowed, must also be in admissible form. So you can't just let in hearsay statements, whatever, no hearsays coming in. The court must balance the probative value of the proffered evidence, how old it is, what is its nature, how necessary is it to the people's case on the issue in question, what other evidence is there on the matter, against the potential for undue prejudice, which is huge, right? I think we can all agree that. But what I really think is interesting is this bit here. How necessary is it to the people's case on the issue in question? The entire theory of their case was, hey, jury, you're gonna decide, right? We're gonna present our case and we want you to decide that what happened on March 25th was this thing that Jonathan Majors did. Hold him accountable for it. Because it was a pattern. There was a pattern here of abuse that culminated in the actions that happened on March 25th. So the prosecution's entire case necessarily relied upon this Molineux evidence that even before this Weinstein ruling, this overturned the appeal, very, very questionable admissibility. So, but judges enjoy a broad range of discretion with respect to evidentiary rulings. And they're not likely to be reversed unless that discretion has been abused and the proof in the case otherwise is not so overwhelming as to render the error harmless. So, this would be an extremely harmless error because it's exactly what the jury could have convicted Jonathan Majors because of, right? Next element, and this is the fourth and final, if the court decides to admit the evidence of prior bad acts, defense counsel should request, and the court must give the jury a limiting instruction, which sets forth the permissible purpose for which the evidence will be received and may be considered during deliberations. So, and also it preserves the defense, there's a waiver of the issue on purposes of appeal. So the defense did their job, and that's why we saw this. For like 2 days worth of testimony, that's why we kept seeing this instruction. So, ladies and gentlemen, you just heard about an incident that Ms. Jabari testified happened between her and Mr. Majors in December of 2021. And that evidence, this was the dog argument. and that evidence is not offered and must not be considered for the purpose of proving that the defendant had a propensity or a predisposition to commit the crime charged in this case. It's offered as evidence for your consideration as background information. If you find the information is, or evidence is believable, you may consider it for that limited purpose and for no other purpose. And they read this instruction after each thing that Grace Jabari testified through, besides the night of March 25th itself. Now, if we hop over where do I have this case? So I have a PDF, the full appeal decision, and I think I linked it in my other video, guys. I don't think I went and saved my edit to add links to this one, so I'm gonna have to remember to do that after we're done here. But if you want to read the Harvey Weinstein appeal decision in full, it's 70 pages. There's a dissenting opinion. That link is in the last video I did, and I'll update it to be in the description here as well. But let's get that PDF up, because I've got some highlights, because we're not going to read the whole thing. Let's see. And then while I've got this up, before we get into it, I know you guys are over here already. So Pam, I hope this is getting you through the workday. Hey Pam. Hey Sheep Animations. And then Michael Sanchez, I know you were in earlier. I'm not sure if you're still here, but hey if you are. Hey Juanita. And then you came in with the full energy, Enigma. And then hey Carol, how are you? Brandon, Barbara came in with the full energy. Still has Madonna stuck in your head. Hey Mr. Minutes. Hey Ghost. And then yeah, New York pretty much has a general best practices guidelines for rules of evidence. And yeah, they completely ignored all the exculpatory evidence from Jonathan Majors. And maybe this is a good moment to pull something up that maybe most people won't be surprised by, but you know, if there's something confirming a suspicion. Let me switch back over. Grace Jabari had a very interesting Instagram story yesterday, and I caught it at 23 hours, and then it was gone when I refreshed the window. But she had this story. It says, "Okay, I cannot cope. My sister passed the New York bar exam first time. I'm so proud of you, sis. I might burst of pride. Oh my God. And on top of studying alone, with no school or institution to help, with 2 babies under 2 years old. Shout out to moms. You also held my hand through the hell I was in." So what is she referring to? You also held my hand through the hell I was in. Coming to everything with me in person and on the phone when I was in London. If you're saying you were coming with me in person and on the phone when I was in London, those items are tied together, right? You were coming to everything with me in person through the hell I was going through. We know she wasn't at Bellevue with her sister. This must be referring to all of the meeting with the prosecutors, meeting with Galloway, meeting with Ross Kramer and whoever from the Sanctuary for Families of New York. It's got to be tied into that, or else what other hell was she going through? And on the phone while I was in London, right? So it's not just general meetings. You were on the phone in London to do what exactly? Ms. Jabari, on March 27th, 2 days after these events, you met with the district attorney's office, correct? I was in UK, so we had a Zoom conversation. I believe that's what you're referring to. Then another part. But you've met with the district attorneys in this case several times, right? Correct. And how many times have you met with them? Including about 3 or 4 times in person, and then like 2 or 3 times on Zoom, as I was in the UK. And how long were those sessions? Varied, some were short, some were like an hour or so. When was the last time you met with the district attorney's office before you took the stand? I think 2 days before, the day after I arrived in New York, so on the weekend, Saturday. And when you met with the district attorneys, they went over what questions they were going to ask you on the stand, correct? Not exactly, but some, I guess. Well, they were preparing you for your testimony, right? Correct. And they were preparing you for the answers you would give, correct? No. Perez objects, court overrules. She says no. They went over evidence in this case with you, correct? They showed me what they were going to be using as evidence. Yes. So, the reason that's all important is, as we've all suspected, her parents are lawyers, right? Or at least one of them's a lawyer. And then her sister's been in law school. And she has her sister sitting in when she's giving statements and doing her interviews with the District Attorney of New York, even when they're taking place virtually. Not just when it's in New York and her sister happens to live in New York. So, when we were going through those transcripts, if you were there when we went through those transcripts about why the injuries, Jonathan Majors' injuries, were not admissible, because Grace Jabari said, that looks like, the side of his face, but I'm not sure that the shirt he's wearing is his shirt. The judge was like, oh, we're not going to let those pictures in, not admissible. Nope, sorry. So the jury never got to see evidence of Jonathan Majors' face having a cut, his arm having a clear fingernail scratch, someone scratching him, ripped coat buttons. Jury never gets to see it. Interesting. Very, very, very interesting. And then, hey, Frankenstein, how are you? And then, hey, Daisy. Yeah, you might want to do some... Daisy, if you don't know Daisy, I think Barbara hasn't caught up yet, but Barbara calls her the Hermione of this channel because Daisy does the homework, gets all the details together. And I'm sure when Daisy, when you catch up when you're hearing this part, I'm so glad that you're in here with us for this. And Ghost, I think you mean Grace, gets on your nerves. And then it's hard to take anything she says at face value, but then she hit it, so. So yeah, going back to this lovely New York font, we are now looking at, oh, wait, hold on. Oh, what? Do you guys see that familiar name on the screen? They wrote an amicus brief. That is interesting. I would love to read that. There's no indication on what side they filed for. But what side do you think Sanctuary for Families filed their amicus briefing for? I wonder if we could request that through public records. I will try. New York is very slow, but I will try. So, welcome to all my dots. I didn't realize that when I opened this. And I've looked at this like 4 or 5 times now. Anyway, we're going to get into the decision here. And I'm going to try to skip over things that are just really not relevant or just repeat the same thing. We're going to get to the meat and bones. But we're going to cover some very general things and some very specific things from the Weinstein case, at least in terms of how the prosecution asked for certain evidence to be admitted, compare it to what happened in the Jonathan Majors trial, and then look at some case law. And what I think is really great for the preparation of the appeal for Jonathan Majors is not only is this decision very favorable case law for the appellate issue of all of Grace Jabari's testimony of prior incidents, but this lays out a lot of other supporting case law, right? So they can go through this, and this is like a little Rolodex for someone to file an appeal on the same issue. But let's see what they say. Every person accused of a crime, and I think I can make this wider. StreamYard, again, always really sucks about... Okay, let's do that. Every person accused of a crime is constitutionally presumed innocent and entitled to a fair trial. I want to get to my highlighter. The right to a fair trial is a fundamental liberty secured by the 14th Amendment, and the presumption of innocence, although not articulated in the Constitution, is a basic component of a fair trial under our system of justice. Whether rooted directly in the Due Process Clause of the 14th Amendment or in the compulsory process of confrontation clauses of the 6th Amendment, so the right to confront your accuser, the Constitution guarantees criminal defendants a meaningful opportunity to present a complete defense. Under our system of justice, the accused has a right to be held to account only for the crime charged, and thus allegations of prior bad acts may not be admitted against them for the sole purpose of establishing their propensity for criminality. This is from the famous Molineux case. Nor may the prosecution use prior convictions of or proof of the prior commission of specific criminal, vicious, or immoral acts, right? So that covers things like yelling at somebody. You might think yelling at somebody and telling them you're not following the plan and why can't you be more like Coretta Scott King and Michelle Obama? If you want to make the argument that that's immoral, there's some standards here. It is our solemn duty to diligently guard these rights regardless of the crime charged, the reputation of the accused, or the pressure to convict. It is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. So, most favorable to the defendant. The defendant has the right. Defendant was convicted by a jury, and again, we're talking about Weinstein here, guys. This is the Weinstein decision, and we're just going to draw relevant parallels when one exists. Defendant was convicted by a jury for various sexual crimes against 3 named complainants, and, on appeal, claims that he was judged not on the conduct for which he was indicted, but on irrelevant, prejudicial, and untested allegations of prior bad acts. We conclude that the trial court erroneously admitted testimony of uncharged, alleged, prior sexual acts against persons other than the complainants of the underlying crimes because that testimony served no material non-propensity purpose. In other words, this court, the High Court of New York, found that you only introduced Molineux evidence from 3 other witnesses, non-complainant witnesses, for the purpose of, yeah, he's inclined to do that, so you should think he was more likely to commit these things we're charging him with. The court compounded that error when it ruled that the defendant, who had no criminal history, could be cross-examined about those allegations. This is the Sandoval rule that I keep mentioning. And we just don't have the information available to us. We know that Jonathan Majors didn't testify in his trial, and some people have asked why. But with the Sandoval rule, if the prosecution had asked and the judge said, oh, I would allow it, the prosecution could have gotten permission ahead of trial from the judge. Hey, if he goes up to take the stand, we want to be able to ask him about these other things that don't really relate to what he's charged for on March 25th. But we want to ask him about that time he made a mean face to somebody or yelled at somebody on a movie set. If the judge said ahead of time, which is what happened in the Harvey Weinstein case in New York, yeah, you'd be able to, do some examination on the defendant if he takes a stand on those topics. Well, that could be another factor that we're unaware of that might have influenced, the decision for Jonathan Majors not to take the stand. Because what happens if you get up on the stand and the prosecution's allowed to say, hey, even though you gave us testimony that's very convincing about March 25th, but we take you through 2 hours of telling you how you're a bad person on a movie set, what could the jury start thinking? So the synergistic effect of these 2 errors, so Molineux evidence and potential Sandoval with testimony about prior things that have nothing to do with the charges, was not harmless. The only evidence against defendant was the complainant's testimony, and the result of the court's rulings, on the one hand, was to bolster their credibility and diminish defendant's character before the jury. On the other hand, the threat of a cross-examination highlighting these untested allegations undermined defendant's right to testify. The remedy for these egregious errors is a new trial. Now, I'm absolutely positive that we're going to see a Molineux issue raised on appeal from the Majors team. If there was a Sandoval issue, that's another appellate issue we could see with whatever Priya and Seth bring forward on the Majors appeal. So I'll be interested in seeing that. Again, it's just covering it here. That way, in case we see it in Jonathan Majors' appeal, you guys already have a background understanding of what exactly that means. So the court here, they're rejecting, this should have been left outside the statute of limitations. So they did find in this appeal, Harvey Weinstein, we're not granting you everything you've asked for on your appeal. Now, they have a footnote here that in the Weinstein case, and we've talked about this difference, all of the counts include a component of intent to commit the act charged without the victim's consent. If you're joining late, that's an important difference here because Molineux evidence, it has to be introduced for something establishing a non-propensity element of the crime, such as intent or identity of the perpetrator. Well, in the Jonathan Majors case, the trier of fact has already determined they're going to acquit. They acquitted Jonathan Majors of the intentional acts and found him guilty of 2 reckless acts. Big issue, especially if you have a high court reminding us all that, Molineux can't do it for propensity, but you can do it for intent. But if the trier of fact, the jury already found, as a matter of fact, no intent. Intent can't be the reason you ask the judge to allow you to bring in Molineux evidence. So if there was a retrial, that's a huge deal. Now, before the trial, the court granted the prosecution's application to admit certain testimony of uncharged crimes and miscellaneous bad acts as an exception to the Molineux rule, prohibiting such evidence to establish defendant's intent and his understanding of the complainant's lack of consent. Thus, complainant B, now I want to be clear, there's 3 complainants and 3 Molineux witnesses in the Weinstein trial. So sometimes when you see the A, B, and C, read the word before it to know if we're talking about a complainant versus Molineux evidence. In the Jonathan Majors trial, Grace Jabari, the complainant, was also the only person to be a witness to Molineux evidence. So, thus, complainant B could testify about defendant's uncharged sexual assault against her before and after the charged rape and her awareness of defendant's abusive and threatening behavior. The 3 other women, the Molineux witnesses, could testify regarding defendant's sexual misconduct towards them years before and after the charged offenses involving complainants A and B. So, major difference between the 2 trials is when it comes to who's testifying, the only person to give credibility to a complainant is the complainant themselves. There is no other witness that came in the Majors trial that said, yeah, what happened to her, I had the same thing happen to me. The court also granted in large part, over defendant's objection, the prosecution's Sandoval application to cross-examine defendant on a broad range of uncharged bad acts should he testify. So again, I do really think that we might get some information that signals if Jonathan Majors were to take the stand, Gaffey was going to let some rabbit hole questioning start to take place. After the court denied defendant's motion to dismiss the 3rd-degree rape charges time barred, the case proceeded to trial. Now, this isn't really that important, except they're going to go through the different things that were alleged, right? But in the Weinstein case, the complainants there's an element of, he did these things to me, and I thought there was a job opportunity promised on the other end. Meanwhile, the Molineux witnesses had a shorter duration, right? So the complainants had an extended relationship where they were given some promise and they believed it was going to be given to them, and abuse happened to them as a result of their belief in this promise that was never fulfilled. That's a really poor paraphrasing. But the witnesses had a much shorter interaction, possibly just a single one-off interaction. The reason that becomes an issue in short is the relevance. When you introduce Molineux evidence and you're supposed to decide if it's admissible, it has to be relevant. So if someone's saying, all right, he walked by me and grabbed my butt, that might not exactly be relevant evidence to help support a claim from a complainant that, hey, we were in a room and he tried to engage in a sexual act with me and I tried to push him away, but he kept trying anyway. That's not, in this case, there's an issue of relevance because the propensity of hitting someone, like grabbing someone in the butt, doesn't necessarily suggest that somebody had intent with that Molineux witness that's parallel to what was happening with these other complainants. So there's a specificity element where just because I yell at someone on a movie set doesn't mean that should be admissible so the prosecution can use it to win their claim against me, their charge against me, that I committed assault against somebody. That's the only reason this is relevant, but we're not going to go through. I really don't want to read all of the specific facts from the Weinstein case. So we're going to skip a lot of this. It's there if you want to get the summary, the full description in my previous video. Now we're going to get to the Molineux issue. The 3 Molineux witnesses testified about defendant's individual unwanted sexual advances towards them. Witness 1, and we're going to skip the details here, but this is really that difference. So he puts his hand up her skirt, tries to do some gross things, and then a few weeks later she agrees to meet the defendant at another hotel, clothed in a bathrobe. He told her that he would sign contracts for her to work only if she had sex with him and his assistant. Why do people always try to bring in somebody else on the action? Wouldn't that just be another witness? People are weird. And then told her he was joking and that she would never make it in this business unless she changed her attitude. Now, witness 2 testifies, well, we meet in 2005. I was an aspiring actor. Weinstein gave me his contact information, but then minutes later grabbed me by the arm, led me upstairs to a deserted terrace, then pulled her. So she was facing him, and then he started masturbating. So now witness 2 a week later was invited to read for a part at defendant's production company, but while waiting in the waiting room, was told that defendant wanted to see her at his apartment. When she arrived, defendant grabbed her arms and threw her on his bed before removing her clothes and having intercourse with her as she just froze and looked off. So, this is really where I want you to pay attention. Witness 2 explained that the defendant was a heavy man who weighed her down. Defendant then drove witness 2 back to the studio, but she was not allowed to audition and did not get the part. Then they go through witness 3. And then, let me find it. I should have highlighted this in advance, but we're going to see that weighed down, weight of the body. This type of verbiage that comes really not from a witness speaking casually, but is ultimately likely derived from the language of a legal complaint, a legal filing, a prosecutor's, questioning. The weight of the body, certain terms. Why? Because if you parallel the correct terms, now you have parallel situation. You're not talking about someone yelling at on a movie set and trying to compare it to, DV on March 25th. You're saying, he assaulted me with intent. I could feel the weight of his body pushing down on me. And he tried to put his hand on my throat, right? Pam is always the one that points out, why do we see that specific terminology, the strangle word, so many times? Well, if you have 2 people alleging those same specific things, the specificity is there, it makes it easier for not just, Molineux witness evidence to be admissible in New York. Again, the judge has discretion, wide discretion. But it could also be something that with Sandoval, the prosecution could question, could have a better chance convincing a judge, hey, if the defendant decides to take the stand in their own trial, we can question them on this, right? Because it's specifically relevant. So that's why you're going to see that draw of certain terminology being very important. It comes up, they go through a lot of this because we're only on page 11 out of, I think 40 is the main opinion, and then the dissenting opinion, and then there's indices at the end. But we're going to see that weighed down, the weight of his body term used again, and that was something that we heard Grace Jabari use explicitly while describing what was happening in the first part of the car. Following the testimonies of these 3 Molineux witnesses, the trial court instructed the jury that this evidence must not be considered for the purpose of proving that the defendant had a propensity or a predisposition to commit the crimes charged. So they read this same, hey, everything you just heard, jury, it's just to consider it for background information only, not for propensity of this crime being charged here. Same instructions, similar instructions at least, were given here. The court further explained that the prosecution introduced the Molineux witnesses to the jurors for their consideration on the question of whether the defendant intended to engage in the sexual acts and whether each of the complaining witnesses consented. And we know what? In the Jonathan Majors trial, which is not true for Harvey Weinstein, in the Jonathan Majors trial, the finder of fact, the jury, concluded no intent. During the final charge to the jury, the court reiterated that the testimonies of the Molineux witnesses was offered for its considerations on the issue of forcible compulsion and lack of consent. The prosecution also presented testimony from a forensic psychiatrist and expert on rape trauma syndrome. Now, this is actually, when you hear about expert testimony coming in, this is something that prosecutions actually, it's a benefit afforded to prosecutors, where, all right, we know that, just academically, statistically, victims of traumatic experiences may have certain ways that they speak to the things that they experienced that could come off as not making sense to a juror or not sounding reasonable on its face, even if they're true, even if everything they're saying is true. Then there's also the whole rejection. There's a stigma, right? There are people that just don't believe that rape happens at the rate that it might occur, right? So jury, you've got to give the prosecution some room to work with to say, hey, look, we know it might seem weird that someone behaved a certain way, but this expert's going to explain to you why it's not uncommon for people that have experienced something like what's being alleged here would act in such a way. And then that expert's allowed to come in and give that testimony. So same thing, we have the prosecution bring in an expert in the Weinstein trial. And then when all is said and done, the jury ends up acquitting Weinstein of both counts of predatory sexual assault and first-degree rape, but convicted him of first-degree criminal sexual activity and third-degree rape. And then he's sentenced. So that's nothing new. And again, guys, the difference here is this is still, acts that involve intent, right? And they're crimes. They're not just, one's not just a violation. They're both crimes that involve an element of culpability and mens rea. And if he's going back through a retrial, a lot of the stuff that was admissible, there were still 3 complainants. If the prosecution decides to take this to retrial, and I'm pretty sure they will, so the evidence from the complainants themselves might not change very much. But if for some reason Jonathan Majors has a successful appeal and the prosecution wants to retry it, there's going to be an issue because the testimony is going to be limited down to things that are not Molineux evidence. Because there's no longer a need to establish intent because the jury, the finder of fact, has already concluded no intent. So what would the grounds be for a judge to say, well, if you can't do propensity and you can't do intent, and we already know that the identity of the person is Jonathan Majors, right? We don't need this Molineux evidence because it's somebody's MO. It's a serial killer. We need to establish that this person acts the same way to identify them. What other main element would make the Molineux evidence admissible on a retrial for the two charges that he actually was convicted of? It's huge. Like, this is a huge, huge, huge thing for the Jonathan Majors appeal. And I would argue, even without this appeal, that Molineux evidence shouldn't have been admissible anyway. But this case, coming from a high court, narrows down the discretion a judge has and makes it a stronger appellate issue. And then this was a lot of stuff. Case law, we don't need to go through all of that. But here we're going to break down more into the appeal decision regarding Molineux witness testimony. Defendant argues that admission of the Molineux witness's testimony detailing sexual assaults he allegedly committed against them before and after the alleged offense conduct ran afoul of Molineux and its progeny. We agree that this challenge has merit. Indeed, we reject the prosecution's theory, accepted by the appellate division. So that's the court that heard the appeal before the high court. So that court affirmed the conviction. They're like, nope, this is sound. We're not granting you a reversal or anything like that. They continued the appeal up to the high court, and high court said, yeah, there is a problem here. Oh, and I'm missing a sentence. Accepted by the appellate division and the dissenters here, so the dissenting opinion at the bottom, that this testimony showed the defendant's state of mind to use forcible compulsion against complainants and his undertaking of their lack of consent. That analysis, if adopted, would eviscerate the time-tested rule against propensity evidence, which in criminal cases serves as a judicial bulwark against a guilty verdict based on supposition rather than proof, right? So the jury, supposing, oh, that probably happened, they make their decision just based on that, not on actual proof pertaining specifically to the actual crime being charged. So, all of this, all of these rules against propensity evidence are supposed to be a judicial bulwark against a guilty verdict based on supposition rather than proof on collateral matters or because of a defendant's past, or on the defendant's bad character alone. So, which one of these would, a recorded call about you're not following the plan fall under? In Molineux, the court reaffirmed that the general rule of evidence applicable to criminal trials is that the state cannot prove against a defendant any crime not alleged in the indictment, either as the foundation for a separate punishment or as aiding the proofs that they are guilty of the crime charged. The purpose of the rule is simple. Evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case. And again, the material issue of intent. If we go to retrial, not on the table anymore because the fact finder already took that off the table. Intends only to demonstrate the defendant's propensity to commit the crime charged. And it's the prosecution's theory of the case. Pattern of abuse that culminated. The rule is the product of that same humane and enlightened public spirit which, speaking through our common law, has decreed that every person charged with the commission of a crime shall be protected by the presumption of innocence until they have been proven guilty beyond a reasonable doubt. To illustrate the universal acceptance of the rule and the reasons upon which it rests, Molineux quoted its earlier decisions and those of other state courts. For example, the Molineux court noted, as far back as Coleman v. People, the court had explained, that the general rule is against receiving evidence of another offense. A person cannot be convicted of one offense upon proof that they committed another, however persuasive in a moral point of view such evidence may be. It would be easier to believe a person's guilty of one crime if it was known that they had committed another of similar character, or indeed of any character. But the injustice of such a rule in course of justice is apparent. It would lead to convictions upon the particular charge made by proof of other acts in no way connected with it. So in other words, this is how strong this principle is supposed to be. Even if, and this doesn't have to be Jonathan Majors specifically, but we're going to use him because that's who we're talking about. Even if Jonathan Majors had been tried and convicted of another offense, maybe he assaulted somebody and was convicted of it, the general rule would still be against it. Because it wouldn't be just if a conviction for this second charged separate offense was based not on the evidence relating to that particular occurrence of the offense, but rather on the jury hearing, oh, he did that before already. So then think about the issue of bringing in an untested accusation. A story of an untested immoral behavior, such as yelling at somebody in an argument, that the only evidence of is the complainant's testimony themselves. Not another witness that says the same thing, but the complainant is also the Molineux witness backing up the same thing. The court also observed that the following decade in People v. Sharp, Judge Peckham observed in a separate opinion that the general rule is that when a person is put upon trial for one offense that they are to be convicted of, if at all, by evidence, which shows that they are guilty of that offense alone, and that under ordinary circumstances, proof of their guilt of one or a score of other offenses in their lifetime is wholly excluded. The Molineux court recalled that, a few years later, Judge Peckham authored the majority opinion in People v. Shea, explaining the impropriety of giving evidence showing that the accused had been guilty of other crimes merely for the purpose of thereby inferring their guilt of the crime for which they're on trial may be said to have been assumed and consistently maintained by the English courts ever since the common law has itself been in existence. Two antagonistic methods for the judicial investigation of crime and the conduct of criminal trials have existed for many years. One of these methods favors this kind of evidence in order that the tribunal which is engaged in the trial of the accused may have the benefit of the light to be derived from a record of their whole past life, their tendencies, their nature, their associates, their practices, and, in fine, all the facts which go to make up the life of a human being. This is the method which is pursued in France. Sorry, when I read this, I'm sure Barbara in the chat's going to mention it, but, you know, when you think of what was going on with France and royalty, you think of, I know, beheadings and just, oh, we think they did something. And this is just me joking, but the point of this here, this decision, what was it, Shea? Yeah, People v. Shea. Oh, and it's actually citing Sharp, right? So this is two separate New York cases stacking on top of each other, and now this high court, this New York High Court appeal decision, is adopting all of it. They're basically saying, that's ridiculous. We've never done that. If we did that, we'd be pursuing what they do in France, and that wouldn't be justice here according to our own, system of justice. That's not how it works here. So this is the method which is pursued in France, and it is claimed that entire justice is more apt to be done where such course is pursued than where it is omitted. The common law of England, however, has adopted another, and so far the party accused is concerned, a much more merciful doctrine. By that law, the criminal is to be presumed innocent until their guilt is made to appear beyond a reasonable doubt to a jury of 12. In order to prove their guilt, it is not permitted to show their former character, or to prove their guilt of other crimes, merely for the purpose of raising a presumption that they would commit them, or would be more apt to commit the crime in question. So, over and over and over again. Can't use all this past, you can't look back at their whole life to make your case to the jury that they did that, so please infer that they could have done this too. The Molineux court also cited cases from Massachusetts and Pennsylvania that were to a similar effect, noting that the general rule that limits the trial to the immediate act for which the defendant is indicted. So guys, the point here, this repetition, this is the high court adopting case law over and over and over and over and over. And it matters because New York's rules of evidence are just a guidebook of, as Barbara puts it, best practices derived from case law and judicial decisions. There's no codification of it. There's no statutes outlining these are the rules of evidence in New York State. It's case law. And the case law stacks on itself, saying the same thing over and over and over about the admissibility of Molineux evidence. It's very, very good for someone in Jonathan Major's situation. So they cite another case here that it is a general rule that a distinct crime, unconnected with that laid in the indictment, cannot be given in evidence against a prisoner. It is not proper to raise a presumption of guilt on the ground that, having committed one crime, the depravity exhibits makes it likely they would commit another. Molineux recognized exceptions by which evidence of other crimes could be used to prove the charged crime when such evidence tends to establish 1. Motive, intent, the absence of mistake or accident, a common scheme or plan embracing the commission of 2 or more crimes so related to each other that proof of one tends to establish the others, and 5. The identity of the person charged with the commission of the crime on trial. Now, number 4 is really important. Why? Because a pattern is overlapping. A pattern means what? If I'm wearing, if this part of my sleeve, guys, this is gonna get so stupid right here. But if this jacket I'm wearing has an all-over print pattern of ice cream cones, and the shirt I'm wearing had an all-over pattern print of elephants, does this jacket have anything to do with this shirt? Can you say it's one pattern? I'm wearing one pattern? No, I'm wearing 2 patterns. So what did we have in the Jonathan Majors trial? Even if we accept at face value, we give the benefit of veracity to the Molineux witness, who was Grace Jabari herself. The complainant was the sole Molineux witness in the Jonathan Majors trial. It was her own Molineux testimony lending herself credibility as the key witness to proving the prosecution's case. Because they said don't listen to the driver, who said he was doing nothing. She was doing everything. But if what she alleged in all of her Molineux stuff before March 25th, he yelled at me, he made a face, he threw a candle, he was angry, I was downstairs with him and upstairs with him and downstairs and upstairs with him. But then March 25th, you're trying to say he had the intent to hurt you, to put the weight of his body on you, to break your finger. He wanted you to feel pain. Is that a pattern? Is that all one pattern? Or is it ice cream cones prove elephants? Number 4 is really important here. That, hey, Molineux could be used if there was a commonality that these two things, and they say crimes here, but there's been other areas where they've talked about immoral acts, vicious acts as Molineux evidence. But common scheme or plan embracing the commission of 2 or more crimes so related to each other that the proof of one tends to establish the other. Do you think the proof of someone yelling tends to establish that somebody is a domestic violence abuser? Do you think yelling is so related beyond a simple correlation that someone yelling can establish that they assault people? There's a problem. There's a problem with the Molineux evidence in the Jonathan Majors trial for a lot of reasons. But this is really the first time we've gotten to be able to address that particular one. So in 5, the identity of the person charged with the commission of the crime on trial. And we don't need to know that because we know that nobody's disputing that it was Jonathan Majors. In order to be admissible, Molineux evidence must be logically connected to some specific material issue in the case and be directly relevant to it. The prosecution has the burden of showing this direct relevance. In other words, evidence of a defendant's uncharged crimes or prior misconduct is not admissible if it cannot logically be connected to some specific material issue in the case and tends only to demonstrate the defendant's propensity to commit the crime charged. When the proffered Molineux evidence is relevant to some material fact in the case, other than the defendant's propensity to commit the crime charged, it is not to be excluded merely because it shows that the defendants had committed other crimes. So, yeah, you can get Molineux evidence in for the right reason. In reviewing a Molineux ruling, the court engages in a 2-step process. First, it evaluates whether the prosecution has identified some issue other than a mere criminal propensity. So it can't be inclination to just do bad things. That can't be why you get Molineux evidence in, to which the evidence is relevant. This is a question of law, not discretion. And we review it de novo. So if you bring this to us as an appeals court, we're going to look at it that way. Second, if the evidence is relevant to the issue aside from propensity, so intent, identity, all of those things, the court determines whether its probative value exceeds the potential for prejudice resulting to the defendant. Now, this is the court's determining this, right? There's room for discretion here, right? But at this step, the court's decision to admit the evidence may not be disturbed simply because a contrary determination could have been made or would have been reasonable. Rather, it must constitute an abuse of discretion as a matter of law. However, any substantial doubt regarding how to strike a neat balance between possible prejudice to the defendant and indispensability of the challenged evidence to the prosecution's case should weigh the scales in favor of the defendant. So remember at the very beginning of this video, we looked at, hey, when the judge is using this discretion, one thing it might need to consider is, does the prosecution need to rely on this to establish their case, right? And we know that the prosecution's entire case was a pattern of abuse that culminated with the physical act on March 25th. But how is this supposed to be viewed if you're the judge and you find yourself in a catch-22? well, this could prejudice the defendant, but the prosecution also needs this because their case depends on it. Here it says, however, any substantial doubt regarding how to strike a neat balance between possible prejudice to the defendant and indispensability of the challenged evidence of the prosecution's case should weight the scales in favor of the defendant. This is huge. If the court concludes that the trial court abused its discretion by admitting Molineux evidence, the court must determine whether the error was harmless or requires a new trial. The Molineux ruling here, and then we're back to speaking about the Harvey Weinstein case. So guys, it's my understanding, right, my interpretation reading this, that these judges, at least the ones that are, the majority opinion here, because there is a dissent. The dissenting opinion, I didn't get to read it, but maybe they just really stand firm that they don't want this particular thing. They don't want to throw a bone over to Weinstein. But we've read plenty of pages here that have nothing to do with the actual specific facts or charges that were levied against Weinstein, right? This is pages and pages of them just looking at the rule of law, the letter of the law, and making a decision. And these judges really want to preserve and stand 10 toes down on what Molineux is supposed to do. It's supposed to serve as a judicial bulwark to someone coming in and taking your entire life. And if you're ever charged of something, that a prosecutor, that the government could come and take your entire life. And regardless of whatever happened relevant to the specific thing you're charged with, they can just look at your whole life and find things that say, oh yeah, he had a propensity for doing this. This high court, so if you're upset about this decision, don't look at it as throwing a bone to an individual person. This ruling looks to me like a bunch of appeals court judges saying, look, we are not going to allow prosecutors to just take someone's entire life and hold it against them in the case that the actual proof they have relating to the charged crime isn't enough to convince a jury. So the Molineux ruling here in the Weinstein case fails at step 1. The trial court admitted the evidence to show defendant's forcible intent when he had sexual relations with the complainants, rebut his claim of consent, and explain why complainants were hesitant to report these assaults. The prosecution then argues that the unusual nature of the entertainment industry and defendant's then outsized role in it, popular misconceptions about the behavior of sexual assault victims, and the complainant's acceptance of favors from him, and, in one case, their continued consensual sexual relations with the defendant following the assaults, rendered their testimonies equivocal on the issue of defendant's intent. So that similarity in that relevance. Thus, the prosecution contends the trial court properly admitted the 3 Molineux witnesses' testimonies to show his unlawful intent. We disagree and conclude that, as a matter of law, the trial court erroneously held that the prosecution showed that the Molineux witnesses' testimonies were necessary for a non-propensity purpose. First, the complainant's respective testimonies were not equivocal on the issue of consent. Complainant A described a violent, forcible sexual assault, as well as her efforts to resist by kicking and pushing defendant. Complainant B testified that defendant physically blocked her attempt to leave the hotel room on March 23, 2013, and that, when she did not comply with his demand that she undress, he grabbed her hand to force compliance. Complainant C testified that defendant lunged at her, and when she tried to walk away, defendant used his weight to lead her to the bedroom, where she fell backward onto the bed. She tried to leave, but he pushed her back. She kicked and pushed to get away, but defendant used physical force to hold her down with her hands above her head and then forced himself on her as she cried and continued to say no. There is no equivocality regarding consent when a person says no to a sexual encounter, tries to leave, and attempts to physically resist their attacker before succumbing to the attacker's brute physical force. No reasonable person would understand such behavior as having communicated anything other than the rejection of sexual activity. Now, why do I think this part is so important? So the prosecution in the Weinstein case, right? This whole section that we're looking at. Prosecution in the Weinstein case says, we need to let this in because it shows equivocation. But what are these acts that the court is saying no reasonable person would understand it as anything but that? So you don't need to admit it to establish that. You don't need to admit Molineux evidence to establish that someone blocking someone versus holding them back is not that person trying to prevent someone from leaving. Or the person that's being prevented from leaving saying, no, I don't consent to this. But who was doing what on March 25th if we look at the Jonathan Majors case? We do have her testimony saying, I felt his weight on me. And he pushed me back in the car. But everything else, who was trying to leave? Who was pushing to get away? Right? We have he pushed her back, but she also pushed to get away in the Weinstein case. What do we have in the Jonathan Majors case? Well, she says that he pushed her into the car. And we know from video evidence he did what after? Tried to leave, tried to get away. We have her testimony saying, I grabbed him because I didn't want him to leave. The complainant and Molineux witness in the Jonathan Majors case, used her physical force to try to stop him from leaving, ripping his coat, ripping his buttons. And here, the appeals court says those such things, that no reasonable person would understand that as communicating anything other than rejection. Trying to get away. Doesn't want to be a part of it. Isn't that funny? So this doesn't really have to do with the admission of something being, admissible as a Molineux evidence. But we do have a high court saying, hey, if somebody's trying to prevent someone from getting away when they're trying to leave, that's just bad on its face. It doesn't even need to be established by an extra witness. It's just inherently bad. And a reasonable person could understand it without explanation. If you're new to the Jonathan Majors case, because you found this channel some other way, and you have not seen the video of Grace Jabari chasing Jonathan Majors, and you have not seen some of the transcripts of her own testimony, where she talks about, in her own words, why she chased him, why she struck him, why she grabbed and ripped his coat, why she chased him again, why she called him 32 times. I mean, I don't even think you need to go watch it. If you take me at face value, if you don't think I'm lying about each of the bullet points I said, because it's her testimony. Her testimony and then the video evidence of her chasing him for 5 blocks until he loses her. I don't think you even need much more detail than that. Those 3 things are pretty big check boxes in favor of Jonathan Majors. But what's the difference here with the Weinstein case, right? Weinstein's not saying, oh no, these people that are saying that I sexually assaulted and raped them, no, it was the other way around. They did that to me. That's not happening here. That's not even a thing here. It's not a parallel. But separately, and what's unique and distinct about the Jonathan Majors case is 2 NYPD precincts found probable cause to arrest Grace Jabari for criminal mischief and domestic assault. The Sanctuary for Families of New York, who wrote an amicus brief for the Harvey Weinstein appeal decision here, which is interesting. They said, oh, we're going to contact Grace Jabari's pro bono attorney, went to Detective Mejia from the 2nd precinct that found probable cause and was planning to arrest Grace Jabari. They got the precinct to do something that was completely outside of protocol, completely exceptional, and instead issued a desk appearance ticket rather than an arrest warrant, which Detective Mejia tried to testify is not something they ever do for someone charged with the offense of domestic assault or criminal mischief. But Grace Jabari very luckily got an exception. And then the jury wasn't able to hear about those injuries, the ripped jacket, none of that. But in Jonathan Majors' case, even if we just look at Grace's testimony alone, there's evidence on the record that suggests the actual aggressor in the situation could have been the person who said, I started the physical fight over the phone. Who said, I grabbed him because I didn't want him to leave. Not only is there a possibility or a claim or whatever, but there is evidence within the record of the trial that Grace Jabari was actually the aggressor and not Jonathan Majors. Big, huge difference. So, nor did the fact, and I think I only wanted to read this part here where the dot is, but let me make sure. As the court has explained, where the crime requires the prosecution to prove forcible compulsion, the intent required is the intent to perform the prohibited act, i.e. the intent to forcibly compel another to engage in the sexual act. And when it comes to Molineux, evidence sought to be introduced to prove a defendant's intention in the crime charged. The probative balance has generally warranted admission of this evidence only where the acts involved in the crimes charged are equivocal, so that intention is not easily inferred from the acts alone. So, you can't use intent of someone trying to yell and be mean to prove intent in an alleged physical assault. In other words, evidence of prior criminal acts to prove intent will often be unnecessary and therefore should be precluded, even though marginally relevant, where intent may easily be inferred from the commission of the act itself. Here, this proposed basis for admitting the Molineux witness's testimony is a candid acknowledgement that the true purpose of this evidence was to bolster complainant's credibilities. What's the problem with that, guys? We have 3 Molineux witnesses and 3 complainants in the Harvey Weinstein case in New York. 6 individuals. We have 1 complainant and 1 Molineux witness. That's the same person in the Jonathan Majors case. What's the problem with that? Here, this proposed basis for admitting Molineux witness testimony is a candid acknowledgement that the true purpose of this evidence was to bolster complainant's credibilities by showing that others behaved similarly towards defendant even after he made unwanted sexual demands. Of course, this is an impermissible propensity purpose, and the trial court therefore should not have admitted the evidence. Grace Jabari gave untested testimony that bolstered her own credibility for what she was complaining about March 25th, and the jury was not able to see other evidence from other sources that established her as the aggressor. They didn't see his injuries. The court sustained a million objections when the defense was trying to elicit testimony from Detective Mejia. Grace Jabari herself testified, "Oh, as far as I'm aware, my arrest basically doesn't exist." They wouldn't let the body cam audio come in. So all of these things, coincidentally, that could have gone against the sole complainant's credibility didn't get in front of a jury. But yet, irrelevant, or maybe marginally relevant, because maybe a candle is technically physical, I don't know, if we want to give it the benefit of the doubt, but something that was either irrelevant or marginally relevant, introduced to establish a pattern. It's 2 strikes against what's supposed to be admissible for Molineux evidence. It was necessary for proving the state's case, but extremely prejudicial to the defendant. It's 3 strikes. Because there can't be a balance there. That balance has to be favorable to the defendant. The weight of the scales of justice need to tip towards the defendant. Why was it allowed in? If it was only meant to bolster the credibility of the complainant. And that's a clear, impermissible propensity purpose. So you have a Molineux witness who is themselves, bolstering the credibility of themselves as a complainant. All while evidence about the injuries, things that would look favorable to the defendant, completely excluded from the jury. And when you really think about it, right? Because that's like kind of something that we can feel, right? When I looking through this case, that's something I felt. And I could put it into words here and there. But when you really like read through something like this, and you pause between each major point that's made, and you connect it back to the Jonathan Majors case, you can put words now to explain why you might feel so robbed. Like, I personally feel like I can't speak to what someone else might feel, right? But I personally felt annoyed, frustrated, angry, upset, almost to the point sometimes where I had to laugh about it. And I'm a third party, right? I'm not personally involved in anything tied to the Jonathan Majors case. But when you see the words laid out, you can put words to why you might feel that way and feel something is so unjust. Something that shouldn't even have been, really, in my opinion, brought to trial. In my opinion, he shouldn't even have ever been arrested. And even if you wanted to arrest someone for the benefit of the doubt, cleaning out a situation, getting people apart from each other and figuring it out as you go, should have been released, not charged. And this is why this appeal, I think, is important. And I'm sure those judges, maybe they didn't want to make this decision because it was Harvey Weinstein specifically. But they wanted to do it for all of these same things that create a burning feeling inside of us that think Jonathan Majors, what he had to go through, was unjust. Saying, reaching this legal conclusion, talking about permissibility of Molineux evidence, we take no step backwards from recent advances in our understanding of how sex crimes are perpetrated and why victims sometimes respond in counterintuitive ways. We're not trying to shut our eyes to the enduring effect of rape culture on notions of consent and intent. So, all of this, we're really not trying to stomp on what we understand can be a tough dynamic for victims. But we can't stomp on really the 6th Amendment and 14th Amendment. So while the Molineux rule addresses jurors' reliance on propensity evidence, contrary to the dissenter's suggestion, we have a means to address jurors' possible disinclination to believe assault victims. So I've talked about this a little bit already, but this is where they get into, this is where we afford the prosecution the benefit of saying, look, things can be nuanced and complex. The proper way to deal with this in a court, to give balance, is educating the jurors about these myths and social misperceptions with expert testimony. Right? So they say, look, that's still permissible. We don't find fault with an expert coming in and explaining how things are. What we do find a problem with is you finding that this Molineux witness testimony was admissible. And then testimonies from 3 individuals about their own unwanted sexual encounters with defendant were therefore unnecessary. So, we're talking about Molineux again. Instead, the testimony served to persuade the jury that, if he had attempted to coerce these 3 witnesses into non-consensual sex, then he did the same to the victims on the dates that under the circumstances as charged. That is pure propensity evidence, and it is inadmissible against a criminal defendant under Molineux and its century-old progeny. So, and then in sum, we conclude that the testimony from the Molineux witnesses was unnecessary to establish defendant's intent and served only to establish defendant's propensity to commit the crimes charged. Neither the prosecution nor the trial court identified some issue other than mere propensity to which the evidence is relevant, and therefore its admission during the prosecution's case in chief was error. So, and we won't go into the Sandoval stuff. We kind of covered that a little bit. You guys kind of got like a general buzz about it. So if we see it mentioned as an appeal issue, we'll know more, but we just don't, with the Majors case, everything is so behind the gate that we don't know what the motions in limine really were unless the news reported on it. So we don't know if there was any, Sandoval rulings pre-trial. But it's something that we'll talk about if we see it come up in the appeal. Without question, this appalling, shameful, repulsive conduct that could only diminish defendant's character before the jury can't come in. And then at the end, the court concludes that, hey, these 2 things together, this Molineux admissibility that shouldn't have been admissible, and the Sandoval rulings, had a synergistic effect that deprived defendant of his right to a fair trial. And this is the case like many other sexual assault prosecutions where the complainant and the defendant are the only ones who know for certain what happened here. Here, the Molineux witness's testimony bolstered complainant's testimony. So again, Jonathan Majors' case, the one witness, Molineux witness, Grace Jabari, testimony bolstered complainant, Grace Jabari's testimony. That's an extra problem that isn't there in the Weinstein case, because it's 3 separate people bolstering 3 other people. This is a person bolstering themselves in the Jonathan Majors case, thereby impacting the jury's credibility determination. As the appellate division observed, the evidence of uncharged acts would show that the defendant demanded sexual favors from aspiring female actors in return for promises or help with their careers, regardless of their agreement to this quid pro quo. The testimony of the 3 Molineux witnesses, although framed as evidence of defendant's intent, was, in courtroom reality, evidence of his propensity to commit the crimes charged. This is not the sole error of constitutional dimension. And then even if that were, they're deprived, so again, they're going to go into Sandoval, we're skipping the Sandoval stuff, but together those 2 things deprive the self-standing constitutional right to a fair trial. And even if that was not the case, even if we assume that these errors were subject to non-constitutional harmless error analysis, we would not deem them harmless. So, gotta do a new trial. And a Molineux error can only be found harmless, or may be found harmless, where the proof of the defendant's guilt without reference to the error is overwhelming, and where there is no significant probability that the jury would have acquitted the defendant had it not been for the error. Do you think Jonathan Majors may have been fully acquitted if the only testimony from Grace Jabari was the stuff that related to March 25th? You know? And here, the whole case turned on a very close question of credibility. The core choice the jury had to make was whether to believe the complainant's respective versions of events. And they cite some cases here. Moreover, the jury had to consider evidence that, both before and after the alleged offense conduct, complainants were outwardly friendly with the defendant and maintained personal contacts. And in the case of complainant B, a years-long relationship that included consensual sex. The jury then had to weigh this evidence against defendant's expert evidence about the effects of trauma on memory and the prosecution's expert testimony that, contrary to public misperceptions about how credible victims respond, sexual assault survivors often exhibit the same behavior. Even if we were to regard the evidence against defendant as overwhelming, was there overwhelming evidence against Jonathan Majors? There remains a significant probability that, absent the court's erroneous Molineux ruling, the jury would have acquitted the defendant. And though harmless error analysis in the context of Sandoval, which we'll get into if that comes up in appeal, we'll talk about that more, it does not involve speculation as to whether a defendant would have testified if the legal error had not occurred. The erroneous Sandoval determination here might have affected defendant's decision whether to testify and provide critical information. So I'm really interested in seeing if Sandoval is an issue on the appeal, or if we ever get to see pretrial motions in limine, to see if there was any indication that the judge said, all right, well, prosecution is asked to be able to ask Jonathan Majors, if he chooses to take the stand, questions about this particular subject. If that was decided upon pre-trial, it'd be really interesting to look at those specific decisions and what those subjects would include, because that could have impacted Jonathan Majors' right to testify. Every defendant has a right to testify. They don't have to testify. They can't be compelled to, incriminate themselves. They shouldn't be, at least. But the idea of, if the judge has pre-approved to the prosecution, well, yeah, if he gets up there, you can ask him about how he treats people on movie sets and keep asking these questions. Sometimes the question itself, people have this idea of, why would they even ask that if it wasn't true? So a question itself, you can't unring a bell. A question itself could put a thought in the jury's mind, no matter what the answer would be. So if Kelly Galloway or Michael Perez got up there and asked Jonathan Majors 20 questions about, his past relationships and people on movie sets that may have complained about him, even though it has nothing to do with Grace Jabari, in my opinion, telling bold-faced lies on March 25th, because she lied in those text messages, guys. In those text messages, there's no note. She repeats in those text messages, you know, I told him that the 911 call, had to do with your concern for my passing out, my being unconscious. But we know, based on the timestamps of her texting her friend and saying that she heard Jonathan Majors trip over her suitcase, and the timing of him knocking on the door, the handyman opening the door, and the police arriving, we know she wasn't unconscious. We know she wasn't passed out. It'd be great if we could hear the police body cam. But during that bit where Priya was trying to elicit, you know, some details about what was being said on the police audio, Grace does say certain things that allude to, I don't know that I passed out. So, you know, but at the same time, Jonathan Majors, there may be a reason besides, we know that with the evidence he said in his interview, we thought there was enough evidence. The driver said he was doing nothing, she was doing everything. I didn't think I needed to get up there and testify. But it came down to a credibility issue for the complainant, who was able to bolster herself because the judge admitted her own testimony as Molineux witness testimony. But here, these such errors are not harmless. How different is our own common law, which is the product of all the wisdom and humanity of all the ages. Under it, the accused comes into a court of justice, panoplied? These words beat me up. Panoplied in the presumption of innocence, which shields them until their guilt is established beyond a reasonable doubt. Their character can be thrown into the balance by no one but themselves. The incidents of their life, not connected with the crime charged, are their sacred possession. They face their accuser in the light of a distinct charge, with the assurance that no one other will be or can be proved against them. So one charge only. This is directly from the People v. Molineux, the case that this is all derived from. These words are no less true and vital today as they were when they were first written by this court in 1901. Over a century later, we reaffirm that no person accused of illegality may be judged on proof of uncharged crimes that only serve to establish the accused's propensity for criminal behavior. At trial, a defendant stands to account for the crimes as charged. Proof of prior crimes and uncharged bad acts are the rare exception to this fundamental rule of criminal law. So this, and there is a similar thing, guys. New York, it's Molineux because of this landmark case, really. But there's similar things. 404B, if you ever hear someone mention 404B, it's, you know, prior bad act evidence. And then they're going to talk about Sandoval here, you know, cross-examination when someone tries to take the stand in their own case. But accordingly, the order of the appellate division should be reversed. So the appeals court that looked at this right before us, this high court, their order should be reversed and a new trial should be ordered. So that's the end. And I'm going to have to edit this video. If you go to my previous video, I'll link to this document. There is a dissenting opinion here. And Flavio, I think I saw you pop up in the chat. I'm going to come over to the chat and talk to you guys. Flavio, do you see all my dots here? Do you see who wrote an amicus brief? Sanctuary for Families wrote an amicus brief. So I don't know if you were in here earlier, Flavio. But just to put that on your radar. And let me see. Should I leave all my dots on the screen, guys? Do you like my dot artwork? Let me see what you guys are chatting about over here. If I skip something, it might just be because I can't figure out what it was relating to now that it's probably 30 minutes old. But I'm going to start, I'm going to go backwards. And I see the other ghost, 8386, has joined the chat, so hey to both ghosts. Daisy's got caught up. And then... That's... Ugh. Chip says, Bill Clinton would bite his victims on the lips. Some say it was a way to keep them from getting away. Now that seems very specific. And relevant, right? Like, well, he used to bite me on the lip to keep me from getting away. Well, he used to bite me on the lip to keep me from getting away. Can't argue the specificity on that one. And then, okay, so Daisy, I think, is pulling the transcripts segments here about that heavyweight language. Like I felt like I have, so this would be Grace Jabari's testimony. Like I felt like a heavy thud on top of me. I felt what I knew to be the weight of him on top of me, and he was really trying to pry the phone out of my fingers. And yeah, there would be no other main element. So again, guys, according to Molineux rules of admissibility, you cannot use past bad acts to establish a propensity. But you might be able to introduce it to establish, intent or the identity of the person committing the crime. So this weird masked man does the same weird thing and says the same thing every time he commits this same act. And you've got 3 witnesses saying, that's what happened to me when I was a victim of it. That's what happened to me when I was a victim. Oh, okay, so it's probably the same guy. And this person, this complainant, was able to identify this actual person as doing it. And this all corroborates together, right? But there's no issue of identity in the Jonathan Majors trial. We know it was Jonathan Majors and Grace Jabari in the car that night. And then intent. And that could be a gray area on appeal, because I'm sure the prosecution's going to be like, well, if the fact finder didn't find intent, then it doesn't matter about the Molineux evidence because they clearly didn't buy into it. I don't think the appeals court I don't think any reasonable appeals court will agree with that, because you can't remove the impact on character, right? Overall character, regardless of intent, but the impact on character assessment for the jury by introducing all this other stuff. So even if the prosecution wants to make a counter argument on appeal and say, well, if they didn't find intent, then you can't use the Molineux issue as an appellate issue because they didn't agree that there was intent. Well, it still could impact character. And according to this new High Court of New York, something like that could clearly impact character. And then, hey, Pam. Yeah, the S word is a big buzzword. And I think I remember saying this earlier, but this is that 4th point I think I was reading was very good for Jonathan Majors. And again, so Daisy's what we were just talking about, the jury ends up speculating. They end up making a decision based on the supposition because of things that they may now feel about Jonathan Majors' character in general across the span of his life, rather than proof of what's being charged of him relating to the night in question, March 25th. And then, so E.G. and Carol's lawyer, Roberta Kaplan, was Harvey Weinstein's lawyer when most of these accusations occurred. Kaplan was known as Harvey's pit bull. Yeah, Roberta Kaplan has been in some interesting places. Because interestingly enough, she was part of Amber Heard's team, and then she disappeared. She had disappeared. Because she was making statements in that same article. I think it was the same article that Waldman was making statements in. She ended up disappearing. She wasn't representing her after that point in time. Right around that point in time, I didn't hear about her being on that case anymore. Maybe she's making amends by going after Trump. I think it's a there's how many lawyers are left in the United States that haven't been somewhat connected to some action, whether criminal or civil, involving Donald Trump at this point, no matter what side of the action they're on, right? There's just been so many people. Yeah, the record of their whole life should not be used against a person in a court of law. And yeah, so I think, Erika, you're saying here, yelling is relative, and nope, it isn't. We were saying, can you just sit there and say that this type of action, yelling at somebody, goes to a tendency to do something else? And this court says, nope, can't do that, and unless you're taking something that's highly relevant. So, do you have a tendency to yell while you're punching someone? Yeah, that might relate to you yelling while you're punching someone on another instance, but does you yelling and never having punched someone during these examples where people say you were yelling, does that show a tendency for you to punch people? So this court lays it, this appeals decision kind of lays out all of those things in judicial language. Yeah, I don't think that's ever gonna stop. I'm so tired of being disappointed by people I appreciated. That's why you can't, like, I don't know. It's not intentional. I usually just don't have time to follow things that are going on with like movies and TV. Sometimes when I hear about a person and see someone disappointed, I'm like, well, I never had time to even watch this thing that they're from, so nothing's ruined for me. So it's like a benefit of me not knowing anything that goes on in the world of entertainment. Oh, okay, so Chip, you talked about it here, so you're probably gonna mention it earlier after I get caught up, but when the Times Up recording came out, Kaplan had to step down as Amber Heard's lawyer. Yep. Okay, so, and then, Denise, I hope you're feeling better. I'm glad you're tuning in. We were discussing parallels because again, all of this stuff is happening in New York, right? This Weinstein appeal, the decision, it's the highest top level court of appeals in New York. And since New York doesn't have a statutory code of evidence, all of their rules of evidence are derived from judicial decisions, essentially. So their whole guide on for judges to say what should be admissible when it comes to evidence is derived from judicial decisions. So if we get a major high court decision on admissibility and rules of evidence, and they're directly related to things that went on in the Jonathan Majors case, this ruling is very favorable to Jonathan Majors. Very, very favorable. And then I want to also get this. Oh, I did it backwards. I wanted to put up one more time something I want to talk about Grace Jabari's redirect testimony. Because, you know, why not revisit the transcript? I think I've got to go back. So right now there's like that instruction. That's supposed to be the Molineux evidence instruction that's sitting on the screen. I got to pull up December 8th. Because one of the reasons I kept harping on specificity and direct relevance, can't just be marginally relevant, is really because of those September text messages that came in on redirect, on Grace Jabari's last day. Let's revisit how those came in, and then I'm going to continue reading your comments, guys. Make that a little bigger. So yeah, we go through all the questions. And you don't have legal training, right? You've never went to law school. Yeah, but we just found out your sister sat in on all of your in-person meetings and phone conferences with the district attorney. You just thanked her in an Instagram story for doing that. So your legally inclined family member was present, but you didn't go to law school. And they tried to clear this up as a reason she didn't understand what she was saying when she signed the domestic incident report and said that Jonathan Majors did this and that to her. Where do we start this? Okay, here. Now, we're thinking of relevance and the idea of Molineux evidence being used to bolster a complainant's testimony and for Molineux evidence to be used to help the prosecution prove their case in a way that prejudices the defendant, because you got to keep the scales tipped in favor of the defendant when doing that, when deciding if that would be admissible or not. So here. What was the first time you noticed pain whilst it was being inflicted onto me? Oh, am I still on the wrong page? Sorry. When was the first time you noticed pain whilst it was being inflicted onto me? I noticed the pain then. Did you yourself call the police? So what are we talking about here? Talking about March 25th. I did not, no. When did you first notice the pain? When it was happening on March 25th. Did you call the police? No. Were you planning on it? No. Were you planning on reporting this incident to any form of law enforcement? No. We're talking about law enforcement. And we know that she actually did, so think about how carefully worded this question is. Were you planning? Were you planning on calling the police? No. We have our own reasons why. We know. She wasn't really passed out. She wanted to be found, but not by police. She was actually shocked when it was police that were standing over her. Her testimony. Were you planning on reporting this incident to any form of law enforcement? No. But we know that she did. We didn't get to hear the body cam audio, but she did testify that she felt safe once he was far enough away and out of the room. That's why she's starting to gesture to Officer Swain. Like, oh, he was doing this to my hand, and we have these motionings, these pantomiming. And then we know she continued to report with Officer Lucero by filling out and signing the domestic incident report that they have to ask her on redirect. Do you have any legal training? Do you know what that means? No. But they ask her, were you planning on reporting this? No, because they don't want to ask her, but you did, right? And somehow we go from this line of questioning to this. You were cross-examined regarding the fact that you told the doctor you didn't know how your injuries were sustained. Now, this goes back to that line of questioning. Now, every news report wants to say that these questions came in because Priya was pressing and she opened the door by asking her why she didn't report what happened to her. That's bad reporting. That's not what opened the door. What opened the door was a cross-examination about her saying, I don't know. I don't know how I got these injuries. It wasn't about an issue of reporting. It was about saying, I don't know. It was about Priya Chaudhry trying to say, and on the body cam audio right now, do you hear yourself telling Officer Swain, telling the officers, that the second time around is when things changed, and that's where you think you got your injury. That's where you think your injuries happened. Oh, no, that's not quite what I hear. Do I have to listen to it again? So it was bad reporting on saying why the door was opened. And if we look at what we just read from the Harvey Weinstein appeal decision, the case law cited in there that's been in existence, right? Because most of that was case law in existence, and they're like, well, we got to reaffirm the stuff that we've held true since 1901, that this court first said in 1901. There has to be relevance. But somehow, we're going from, were you planning on reporting, to law enforcement? No, even though she did. It goes to, you were cross-examined regarding the fact that you told the doctor you didn't know how your injuries were sustained. Yeah. And then we get to the text messages. We go to September 2022. And she can't read them. So the prosecution essentially reads them on the record. And she says, by the way, she just saw them this morning. How do you know that's the same USB you were shown? Because I signed and dated it. So they read it into the record. Kelly Galloway's reading it into the record. Then the court gives the instruction, the Molineux evidence instruction. So it's clearly he found it was admissible under his interpretation of Molineux evidence admissibility rules. And then we go right back to Ms. Jabari, the very first question after reading those text messages onto the record. From Galloway to Jabari. Ms. Jabari, when you met with medical professionals on March 25th, did you know how you had sustained your injuries? Yes. And in the car, you had mentioned that you weren't looking at the defendant when he had caused some of the injuries. Correct. And then they say no one else was in the car but Jonathan and the driver. So did you know who caused your injuries when the police arrived? I did, yes. Why did you say that you didn't know? I was, just scared of the consequences of it, what I would say, how that could affect him. So we don't get to hear the police body cam audio where she's saying she thinks her injuries happened in the second car. But she gets to say in front of the jury, after reading text messages from September 2022, with no testimony about the context of them, nothing to establish, the credibility or meaning of those text messages or how they relate to not just the case at hand, but how it relates to her not planning to tell the police something. And then they just circle back. This is all highly inappropriate. Especially since we can infer that she did tell police officers something while still in the penthouse. And that we know she signed a domestic incident report with one of those same officers on, like, when she arrived at Bellevue. He was preparing it on the way over. She signed and said what she observed. Oh, I don't know what the word observe means because I don't have any legal training. And then, final question. Do you know sitting here today who caused your injuries on March 25th? So she gives his testimony. Yep, I know who did it when the police arrived. I know who did it by the time I spoke to doctors. I know who caused them. It was the defendant, Jonathan. That was it. So where was the relevance met? How do you introduce these text messages after asking a question about not planning to report to police? And then you just allow her to say that you knew how your injuries were caused when the police arrived, but you didn't report to them because you were scared of the consequences. But we don't get to hear the body cam audio where you're being questioned. Remember I said how important a question can be? Where you're being questioned. Are you not telling them that the second time around when he came back around, before you got in the car, something changed? And then in the car, you get back in the car again, and that's when your injuries occurred? And it's stuff like this. So Daisy pulls up another great example of the Grace Jabari language. Yeah, when they asked Grace Jabari about Jonathan Majors leaving, she still used buzzwords. Question was, why was the defendant able to run away? And she said, just a lot stronger than me. In other words, if he wasn't so strong, I would have been able to keep him there, even though he wanted to leave. What does that imply about who was the aggressor and who was the victim in a situation? And yeah, so Denise, you're getting to that heartstring type thing, like, well, I don't want this to kind of let someone that is guilty get away with something, right? But the idea is, it's that philosophical concept of, should 100, I think 100's the number that's always the phrase, right? One person being found guilty when they're innocent and having to serve their sentence, philosophically, is that worse than letting 100 guilty people free? Because me personally, I think if your system's flawed and you just say it's fine because we don't want to let guilty people get away, your system will only kind of start incubating on itself and get worse and worse and become less just. But I think this ruling is really good for defendants in general, because if a prosecution's job, because the prosecution's the government, they're not protected by the Bill of Rights. The defendants were in the United States. The defendants have certain rights afforded to them, particularly 14th Amendment, 6th Amendment. We don't want to take away an individual's rights to give the government more power to say, hey, we have the freedom to take your entire life and hold it against you if we want to win a case against you. I don't think any of us in this chat that have seen more than one video, been part of more than one chat together, would sit there and think, that sounds like a good idea. And then let's see. Yeah, just reiterating that guy McFly. Hey, that guy. I don't know if I've seen you in this chat yet today. But good to see you today. And then you're reiterating that the jury couldn't hear the audio of the body cam footage. And then I want to get to, thanks so much, Erika. That's so sweet. I was about to say, I want to get to Erika. I saw a super chat come in, so I want to skip down to it. And then it's just out of the love of your heart. That's so nice of you. And I'm glad that you joined, because I saw you in Dre's chat earlier. And guys, I don't know what's been going on with my internet. They've been building like condominiums right across the street from me, and I think they're at the point where they might be wiring some stuff. So maybe it's like an infrastructure outside of where I live. It's not, I've tested all my equipment direct to the modem, the coax cables, everything. Swapping, nothing is changing it. But my internet quality has not been very good for about like 6 or 7 days. So I think they must be wiring whatever they're doing over there finally, because the outside is almost completely constructed. They're about to put in the windows. They've brought the appliances in. I think they're setting up their internet infrastructure over there, and it's messing with me. So I was like, I don't know. This morning when I was in Dre's chat and you were like, oh, are you going to do something later? I was like, I know I want to, but I don't want to do something if my internet's going to suck. So hopefully I haven't been lagging. And Erika, I appreciate you so much for just showing love, just pure love. And then I don't remember where I was. You guys are very, and I love seeing it. I love seeing it. And Wally, I think you're rating this at 555. You did miss the bulk of it. But we're in the comments, which is a good summary of what we've gotten through so far. And Flavia says Jonathan will win the appeal. No way a collective of experienced judges will convict him. Now, the problem is, though, is like sometimes it seems like these things need to take it all the way to a higher court, right? So you hear a lot of these decisions sometimes we read, and I forget how it's laid out. It's like, I think the Superior Court in New York is like the base, like it's in the same buildings as the trial court, but some appeals take place right there. And then you go up to district courts, right? And you get all these like division levels, and then you get to the higher court. And I don't know the exact level of tiers, but these courts have slow calendars. So, and we get to these high decisions, like the Weinstein case said, hey, these other courts obviously didn't agree with us, but we think they should have. So we're going to reverse their decisions, and we're going to send this back to a possible retrial. So I agree that at least by the time we get to a high court who just looked at this decision for Harvey Weinstein, I can't imagine the same set of judges. I would be surprised if there was a dissenting opinion if the Majors case goes to the same high court in New York for an appeal. I think it would be a unanimous, full majority, like no majority minority. It would just be full unanimous decision, judicial decision saying, yeah, that was bad Molineux admissibility. And that's only on that one issue, right? Because there's other things, you know, the proper charging, sufficiency of the evidence, the jury instructions. The jury wasn't instructed on the self-defense charge. So the jury couldn't have considered, all right, even if this happened in a reckless act, was the motion Jonathan Majors was engaging in during which Grace Jabbar's injuries could have occurred, was he justified in acting the way he was acting? They weren't given an instruction that told them, hey, if he was trying to either get his personal property back because she took it or was trying to take it, and in that struggle, her finger happened to get injured then, you can find that, yeah, that was what caused her finger injury, was that moment in time, but it could have been justified because here's the justification in New York. You have the right to defend yourself against theft of personal property. And so Erika says they really need to tighten up. This isn't Law and Order SVU. People who really should be in prison are getting off on technicalities. Those who shouldn't get railroaded. And this is an interesting point, right? Because not everybody can afford a great attorney. In fact, when you get to like these appeals levels of people that are maintaining their innocence, a lot of the issue is ineffective assistance of counsel. And, you know, this is speaking in terms of capital murder trials, right? Capital sentences, death penalty cases, or even in cases that don't have the death penalty, it's not capital, but, you know, sentenced for life in prison, where the death penalty isn't an option. You know, a major core of those appeal issues is ineffective assistance of counsel, because when you hear of someone, a defense attorney, a team, or a public defender trying a capital murder case, that eats up all of their time. It is a 24/7, no sleep, like 5 coffees a day type of task. So if you're a public defender and you have 2 capital trials on your desk, or 2, you know, facing life in prison trials on your desk, inherently you're going to be ineffective in providing counsel to your client. And you will see these attorneys argue to appeals courts on their own. Your Honor, I couldn't provide effective counsel to my clients because I had this many serious major cases on my plate as a public defender. And appeals courts will still be like, nope, not good enough. But when you can afford a better attorney, that it increases your chances of making a good argument, making the right argument, having the sheer time and resources to make the appropriate motions to a court, to make the appropriate arguments, include the appropriate case law. Because it's really easy when we're looking at a document and the cases are cited, we can go and take the name of that case where it says People versus Molineux. And we kind of know what that means now, but like a side case we've never heard before, like People versus Cat. Like we can go and Google that once we have the name and know what we're looking for. But if we're trying to look for something for a case that explains a certain topic or argument we're looking to find a basis for or find precedent on, and we don't already know what name of a case to start with, we have to go and identify and discover the cases that could support our argument. That is time consuming. That is hours and hours and hours of research. Do you think the public defender can do that? Someone who has a dedicated research team, an experienced research team, and the time are in a much better position to find out these technicalities where a prosecutor failed. And it really does suck. And the onus, in my opinion, is only on the prosecution, on the government, on the state, for them to tighten up. And to not just expect to win at any cost, and to not just rely on a judge's discretion to get in something that tips the scale in their favor when it should be the benefit of any tilt should be given to the defendant. It's a pet peeve of mine. And luckily, you know, no death penalty in New York, but I'm sure that doesn't mean that their caseloads are any faster, because those courts don't seem to be very efficient. It took how long for Jonathan Major's misdemeanor trial to see a courtroom? We almost had a trial starting on October 26th, I think was the date, maybe the 28th. And then they're like, no, wait, we're going to push it back till December. And then, yeah, that's really how it felt, right? They just wanted to slander Jonathan, to be honest. So they had to bring up old stuff. And what was the makeup of that courtroom? If you listen to, well, it wasn't just Danny. It was also Jimmy and Lauren Victoria Burke. They broke down who was in the courtroom. Even Jimmy said, I was sitting right behind Cheyenne Roundtree. You see who was in that courtroom, and if we didn't have the three of them in there, like, we would have only had the certain quotes from the people that they knew were going to be in attendance, writing their stories. Victoria Becampus, Ben Cockman, Emily Palmer from People magazine. The same reporting where they took these little sound bites of, like, oh, she was in fear, or like all these sound bites that are just her own statements. They make it a headline and people see that and they think that they think, oh, this happened in a courtroom. It's true. On its face. It's bad. And yeah, so shout out to the Fancast podcast. It seems New York seems to have an issue with their entire justice system. And again, this is Alvin Bragg's district. And I'm rooting, when I say I'm like rooting for Priya Chaudhry and her law firm, I'm not just rooting for her because she seems to stand up for people that she I mean, in her own words, she said, why wouldn't I call, and I don't know it exactly, but she said something to the effect of, why wouldn't I call someone a liar or compare them to Carolyn Bryant if they were lying? Like, and however she worded it, referring to Grace Jabari, she received pushback for that comparison. But Priya Chaudhry, you know, she's short, so to me it's like extra cute to think of her doing this, puffing her chest out and being like, yeah, I think she's a liar. And I'm going to defend my client. Because it's not right. And particularly, and she'll take aim at Alvin Bragg and say, Alvin Bragg's office is capitalizing on what people already expect of a stronger, an athletic, a man, a black man, right? So you get all those layers. Black man, athletic, fit, and all of that's going to be held against you. And God forbid a white woman's on the stand crying tears. And there's politics and nonprofit organizations that can get free publicity out of it. They're going to pursue that. They're going to pursue the win, the publicity, and the political benefit. Before they just use common sense, logic, and follow what's just for any criminal defendant going through the system. So, when you say New York, that's especially interesting because this is a Manhattan District Attorney case. And then, yeah, I saw Denise. Why not? Let's go back to the transcription. And then I want to see, I saw a starred comment here. So thank you so much, Chip. Chip says, please keep up the good work. Thank you so much. It's a lot of love. I appreciate that. And I appreciate you being here because you've been contributing in the chat a bunch of times. And then this might be a great note, a great image to end on, guys. Barbara says, you want to see Priya go all Samuel Jackson in the times of time. Yeah. Oh my gosh. Can you imagine? Okay, guys, can you imagine if Samuel L. Jackson was, how tall do you guys think Priya Chaudhry is? Can you imagine if Samuel L. Jackson, everything he's ever been in, but he's Priya Chaudhry's height? That would be phenomenal. I love to picture it. So with that, thank you so much to Erika and Chip. I appreciate you guys so much. One of my favorite things to do, guys, if you ever see me in someone else's chat, I don't know, I just like love the little buzz and support when I get to give it to someone else. So I feel appreciative being on the other end with you guys contributing and just general comments too, you know, you're just saying like love of the game, really appreciate you. Please keep up the good work. I certainly will. And I plan to do so with better internet connection in the coming days if Spectrum ever wants to get it together, or if if fiber optics ever want to install infrastructure near the coast of Florida, which they don't ever seem to want to do. But with that, and with our lovely picture of a short Samuel L. Jackson or a Priya Chaudhry as Samuel L. Jackson, we're going to end this live stream. As soon as we get appeal docs from the Jonathan Majors case, we will do a live. We will go through it, you guys. I'm really excited for it. You guys all take care. Have a great Friday night. And I don't know if Pam is going to do a stream tonight, but she's been doing her stunt shows and shenanigans. They've been really great. So Pam Entertainment TV, if you aren't already subscribed to Pam, I feel like she's going to have a stunt shows and shenanigans about this Weinstein appeal and how it relates to Jonathan Majors. Make sure you check her out. And Dre Mac did a stream this morning talking about it. Give me 10 minutes. I'll have it edited into the description here. Go check those out. You guys all have a great Friday and a great weekend. And thank you so much for all your thoughts and insights.